even if it upheld the procedural.
But your primary stance is, if we are with you with the primaries, we don't need to look at this one. If we are against you,
then you will
then we should.
certainly, if this court is against us on the procedural, it will have to decide the Section 7.2 point. If this court is with us on the procedural, then it is in the court's discretion in my submission as to whether it should deal with the Section 7.2 point. And the points raised by His Lordship Mr. Justice Motley will obviously carry weight in that regard.
Well, ironically, I mean, the same argument can still be made if the whole process is followed from Parliament. Even if Parliament ultimately passes this law of repeal, your client still has the right to make that argument.
I take the point entirely with respect. It's very well made. I take the point. It would not, I must accept that it would not foreclose this argument being made another day if this court were to strike down the government's decision to withdraw and say the whole process has to begin afresh. Could I leave the Section 7.2 point with only this? There are really two, in an analysis of the reasonableness and justifiability of a decision, one's really dealing with a scale. One is dealing with the fact that you are taking retrogressive measures and undermining people's rights on the one hand, and then the question of what is the justification for that on the other. So in other words, in assessing the reasonableness and justifiability of the position, one must weigh that up. I have explained the one side of the scale, that there is a breach of the substantive rights of South African nationals, and that there is a breach of our duties towards the international community. What remains is the question of the reasons that are given. Now, we have dealt with that in a great amount of detail from pages 53 through to page 59. But I don't propose to deal with that in this oral address, because I know that counsel for some of the supporting respondents, including SALT, will do it. And I'm mindful of the court's suggestion that we should avoid repetition. So we stand by everything that is said there. We say with respect that the answers that are given by our learned friends of the government do not answer what we have demonstrated are very flimsy reasons weighed against the compelling human rights concerns, but I'm not going to deal with that in further detail. That leaves only one point, and that is the question of remedy. And the question of remedy must be answered, of course, with regard to, by looking at section 172(1) of the Constitution. Now, this court will know only too well that section 172(1)(a) of the Constitution makes clear that when deciding a constitutional matter within its power, which this is, this court must declare any conduct inconsistent and invalid to the extent of its invalidity. So if this court is with us on any of the four grounds advanced, this court has no discretion and must declare the government's conduct to be unlawful. The only wrinkle is whether there has been any case made out under section 172(1)(b) of the Constitution for that decision to be, that declaration to be suspended. And there Justice Alliance case, which appears in the bundle at page 356. It's in the bundle at page 356, and the relevant section is at page 379. Does the court have that?
Page 356.
Sorry, 357. I beg your pardon. 357 is where the case begins, and the passage I wish to refer to is at 379. At 379, if I could just recall what was being dealt with there, that was the case, of course, about the purported extension of the term of Chief Justice Ngobo, as he then was, under a piece of legislation which had been passed by Parliament. And the legislation and the decision was challenged as unconstitutional and invalid. And the court upheld that contention. And the question was, should the court suspend its declaration of invalidity? In other words, a suspension means the decision is left in place. It is given full force and effect while something happens. And the point that is made there at the foot of page 379 is, in relation to this first difficulty, the court has on a number of occasions laid down guidelines on how and what kind of information should be placed before the court in order to enable an informed decision to be made on this issue. For example, in mystery, this is over the page, it was stated, this is about a suspension order. A party wishing a court to make such an order must provide it with reliable information to justify it doing so. The requisite information will necessarily depend for its detail on the nature of the law in question and the character of the defect to be corrected. Yet, as a general rule, a government organ or other party wishing to keep an unconstitutional provision alive should at least indicate the following, and this is the important one: what negative consequences for justice and good government of an immediately operational declaration of invalidity would be, why other existing measures would not be an adequate stopgap, what legislation on the subject, if any, is in the pipeline, and how much time would reasonably be required to adopt corrective legislation. Parties interested in opposing such an order should be given an opportunity to motivate their opposition. Now, what mystery establishes, and it's endorsed by Justice Alliance, and it's more recently been endorsed by McBride, is that suspension is an extraordinary remedy, and it's not to be given just on the basis of some last-minute legal submission. If you want suspension, in other words, if you want to keep an unconstitutional decision alive, you must plead facts about what the negative consequences would be of an immediate striking down. Here there is none. There is not one fact in these papers which could seriously be suggested to go to whether the question of suspension would be justified. It's not even asked for apart from this throwaway line at the end. And of course, the suggestion that it would be catastrophic consequences is belied by the government's own argument on prematurity. Because in the government's argument on prematurity, it says, well, Parliament might overrule us. Well, in that case, I've explained why that's no answer to this case. But that demonstrates that the executive, on its own version, must be operating on the basis that it's possible that the withdrawal will be overturned before it comes into effect. So our submission is that there is simply no basis for any suspension, and that just as in Justice Alliance, the order must have full and immediate effect in terms of Section 172(1)(a) of the Constitution. That leaves only the question of costs, my lords. We do seek costs. We say that the BioWatch principles apply. If we are to succeed, we are entitled to our costs, and we would submit that in view of the array of authorities and the urgency and complexity of this matter, an unusual order for the costs of 3 counsel would be appropriate. My lords, those are our submissions. Sorry,
Just from the practical point of view.
yes,
Suppose we are not with you.
yes,
Your client is intending to argue all these things in Parliament.
yes,
Suppose Parliament agrees with the executive. The South African law. Where does that leave the remedy that you see? In other words, is the process, the parliamentary process, tainted by the executive decision to withdraw?
yes.
And second, can we separate the executive decision to withdraw and its referral to Parliament? Can we separate?
Yes, my submission is that the answer to the first question is yes, that the referral to Parliament is irremediably tainted. And it's for the reason that I gave earlier, which is Parliament is now being asked not to consider merely whether to withdraw. It's been asked to consider whether to countermand, that's their word, an executive decision to withdraw. In other words, it is being given a decision and it's being said, you decide whether you approve this. You decide whether you want to overrule the executive. And by the way, you must decide before October 2017.
We must trust Parliament that it will do its job.
Of course we must. But with respect, it is not appropriate for the executive to try and put a finger on the scale by saying to Parliament, you will only vote against this if you overrule the executive. The appropriate way to do this is that it would have been tabled in Parliament as a mere proposal, without any decision taken by them. If you think about the way laws are tabled, government doesn't enact a law and then go to Parliament and say, by the way, do you agree? Government tables a law, and there's extensive... I beg your pardon?
Yes.
The executive tables a law, and then it goes to Parliament and there's an extensive debate. That is what should have happened here, and it didn't. So that's the first reason why we say it's tainted. But the second reason why we say it's tainted, my lords, is because the mere approval by Parliament via this process will not cure the invalid statute. Remember that we are here saying that the executive had no power to take this decision as it did. If that is so, then its decision was invalid and void ab initio. That can't be cured by Parliament fixing it later. Why do we say that? Firstly, because, as we've given you the authority from Kruger, it's not possible to ratify a constitutionally invalid act. Secondly, we've given you the authority from Executive Council, which says that a mere after-the-fact consideration of whether to approve doesn't fix the problem. You'll remember in Executive Council, Parliament was given the power, Parliament gave the power to the President to make laws, and then said, but we will check whether the laws are good enough. Constitutional Court said, that is not good enough. And thirdly, and most fundamentally, although you correctly make the point, Justice Mahoka, that my client would be advancing many of the substantive arguments in Parliament, this case is about something different. Parliament has no power to decide that the executive has acted unconstitutionally. Parliament can only decide the merits. It can't decide whether the executive has acted unconstitutionally. There's only one arm of government that can do that, and that is this court and the courts above. And so it is no answer to say, with respect, as our learned friends do, go off to Parliament and it will sort the problem out. It won't, because government has already acted unlawfully and unconstitutionally, and this court must declare that it has acted unlawfully and unconstitutionally. And so to your second question, is it possible to separate out the parliamentary process from the executive decision? The answer is that it's not, because the two are inextricably linked. And you see that from the notice of withdrawal, you see that from the explanatory statement. What government says is, we've withdrawn, and by the way, we're going to go to Parliament. They are inextricably linked. But perhaps more fundamentally, could we just think about the practical effects? If this court tomorrow declares this decision invalid, and government doesn't appeal it, let's just assume that for a moment. Or at the end of the day, the Constitutional Court declares it invalid. There is nothing to stop the executive tabling a proper proposal in Parliament for the withdrawal from the Rome Statute and the repeal of the ICC Implementation Act. That would be perfectly proper. But it must do so on the basis of a clean slate. It can't do it by trying to bootstrap itself on the basis of an invalid decision, which was a nullity at the outset. And in that event, if the executive follows the proper process in that regard and tables it in Parliament, then the issue that would come to the fore would be about, well, is it substantively lawful, the Section 7.2 point. But the process can't be cured by now going to Parliament for all of the reasons that I've given.
Thank you, Mr. Duffy.
Thank you, my lords.
Mr. Kurtz?
Thank you, Mark. May I just grab the lectern? Perhaps it's easier for the court to consider my argument.
You just raise your argument.
I'll do my best. Justices, perhaps it's best that I start at the end of the debate that Mr. Bundler had with the court on this question that was posed to him as to what role this court should play when we know as a fact that Parliament has been seized with the issue, and I will address that up front. But before I do that, perhaps I should just outline how I intend to set out our argument. We intend to address intervention, we intend to address ripeness, and ripeness goes to this question that has just been raised at the end of Mr. Bunder's submissions. I wish to say two things about the context in which this court is seized with the matter, and then we want to raise two issues on the merits, and the merits will deal with the three first legs of our learned friend's address. let me say at the outset that CASAC support the DA in all its submissions, and that we seek to intervene as the second applicant, and we would ask that as second applicant, the relief that the court grants would be the same relief that the DA seeks together with the cost order. But let me turn to this point that was debated at the end of Mr. Butler's debate, submissions. We submit that in paragraph 70 of a Constitutional Court judgment, which we've quoted in full in paragraph 78 of our heads, and we ask that the court goes to paragraph 78 of our heads, just to deal with this point on its head up front. It's a case called Mazibuko NO versus Sisulu NO. It's a judgment of the majority of the Constitutional Court, Moseneki DCJ, in which the debate concerned whether or not the parliamentary rules dealing with motions of no confidence in the President, which is a constitutional issue, were constitutionally valid or not. And what happened is the case went through the Cape High Court and eventually it ended up in the Constitutional Court. And by the time it got to the Constitutional Court, the parliamentary committee dealing with Parliament's rules was seized with the question of that rule dealing with motions of no confidence. And what the Speaker said to the court was this: were you to find that the parliamentary rules are invalid for whatever reason, such as, for example, the rules didn't make proper provision for an urgent debate on motion, the rule is unconstitutional. That was the debate, and that was the Speaker's argument to the Constitutional Court. What Moseneki DCJ stated in paragraph 70, we would submit is a full answer to the debate that was put to Mr. Bundler a short while ago. So what he said was, the Deputy Chief Justice said, I'm therefore unable to agree with the contention of the Speaker that because the parties are in the process of remedying the alleged lacuna in the rules, the direct application should be dismissed. So we would say, in like fashion, the mere fact that Parliament is now seized with, let's call it the repeal bill, is irrelevant for purposes of the debate that's before this court. First, the differences between the applicant, that was the leader of the opposition, and the chief whip of the majority party, making most improbable that the lacuna will be corrected. And then the important sentence, and we've underlined it. Second, once we have found, as we have, that the rules regulating the business of the Programme Committee are unconstitutional, we must so declare. An order of constitutional invalidity is not discretionary. And there's a footnote that we've left out of 172(1) sub A. So what's going on in Parliament for purposes of this case now is utterly irrelevant. And what your lordships are to consider is, was the conduct on the 16th or 17th of October 2016 by the executive, was it lawful at that time? What happened on the 18th, 19th, 20th of October, and between now and the 17th of October 2017 is irrelevant. This court is asked to look at and consider one issue and one issue only: the lawfulness of conduct at the time of the conduct, and that was on the 17th of October 2016. And if the court comes to the conclusion that on the 17th of October 2016 the conduct was unlawful, then this court has no discretion, but it must make the declarator under 172(1)(a) of the Constitution, together with any further just and equitable order. And we would submit that the DA's suggestion that the just and equitable order would be to order the government to write to the Secretary General of the United Nations and tell the United Nations Secretary General that the instrument of withdrawal is withdrawn. So that's our opening as far as the debate that ensued between the bench and our learned friend. As far as the intervention is concerned, CASAC, we rely on that which we say in paragraphs 20 to 32 of our heads of argument. We say that the government have got it wrong in understanding our role in this litigation. In paragraph 27, we explain that the government respondents object to CASAC's intervention. This is in paragraph 27 on page 13, because they say the intervention will ventilate nothing new and it will assist no one. Well, firstly, they're wrong, because what we have regard to our heads of argument, we do say things which are different to the DA, differences of nuance, and I will come to the differences. And in particular, the interesting thing is, the government say, well, I'll turn to it when it comes to the merits of the argument, that we make a different point to the DA to, in effect, kibosh their case. Well, that's just not true. But the point is, we do ventilate new issues, and we would submit that we do assist the court in any event. But that's not the requirement. The requirement is under Rule 12 is, does CASAC have a direct and substantial interest in the result of this case? And footnote 7 of our heads of argument deal with Rule 12 in full. And there can't be a suggestion we would submit that CASAC, when we attach the constitution of CASAC, it's an organization dealing with constitutional advancement, cannot have a direct and substantial interest in the litigation before this court. And indeed, in the constitutional court, in a case called Garvis, in paragraph 33, but in paragraph 29 of our heads, we make the point. An intervening party is not required to show that it will ventilate something new. In Garvis, Sitawu challenged the statute, and Kasatu, who was the mother body of Sitawu, intervened in the challenge. It had identical interests and contentions to Sitawu. As we say in the head, Sitawu was even an affiliate of Kasatu, and the Constitutional Court granted the application to intervene, notwithstanding that it brought nothing new to the debate. Now, I've dealt with ripeness, but I just want to add one point. If the matter's not ripe today,
Is the same on the intervention?
that belonging with cell intervention. On ripeness, I've dealt with it in the sense of referring to the Mazibuku Sisulu case. But I want to add one point. If it's not ripe today, when would it be ripe on the government's argument? On the 16th of October 2017, one day before, on their version, the notice of withdrawal becomes operative, we would submit that would be an unfortunate submission. It's ripe today because unlawful conduct occurred on the 17th of October this year. It's ripe today. And to suggest that it's not ripe today because there are some other processes happening through Parliament or through some other fora is not helpful in the least. Today is the day that the court is seized with it because something happened in October and there's a challenge to that something, and the challenge is that it was unlawful. And that's the end of the ripeness point. I want to turn to the merits, but in dealing with the merits, I want to talk to this question of the context. The Constitutional Court has said over and over that all cases that come before the courts are to be considered in the context of the case. And we want to refer to two contexts in which this case is to be considered. The first is, and we refer to Professor Bassioni, who's probably the preeminent international criminal lawyer on the planet, an Egyptian, when he said the following, and this is the first contextual point that we make. The establishment of the ICC symbolizes and embodies certain fundamental values and expectations shared by all people of the world and is therefore a triumph for all peoples of the world. And we have a reference, it's the legislative history of the International Criminal Court, we can make it available. But that's the context. The ICC symbolizes and embodies certain fundamental values and expectations of all people in the world, and it is a triumph for all peoples of the world. The second context that we refer to is in paragraph 10 of our heads of argument, where the commentator Lee said the following. And this goes to our merits argument, and we want to stand back from Mr. Bunton's presentation in a sense and place his detailed analysis and construction of 231.2 in a broader, more high-level context. And I'll come to that after I just read to you the court what Professor Lee said. He says, at the core of a state's sovereignty and constitution are criminal jurisdiction, protection of national and privileges of government officials. Implementing the ICC statute and accepting the court's functions, particularly with respect to the investigation, surrender and arrest of subjects, will inevitably touch upon all these issues and might impact on the state's sovereignty and constitution. An important point he makes is this, for the purpose of the context. All these and other sensitive issues were raised during the negotiation of the statute, the Rome Statute. To allay various spheres, a series of effective ways and means were built into the statute to minimize the effect on national systems and to make the statute acceptable to as many states as possible. So what we say is the two contexts that this court is now seized with, for purpose of this case, is one, the statute symbolizes this notion of those who commit the most serious crimes known to humankind must be held accountable. It's a core principle of international criminal law. Secondly, victims of these heinous crimes should be provided a remedy. And those two principles underlie the basis of why Professor Bassioni made the point that the establishment of this permanent international criminal court symbolizes the values and expectations shared by all peoples of the world. And then this question of, we have an international treaty, a multilateral treaty, where states who become parties to it give up, and I use this word loosely, give up part of their sovereignty. What does that mean? And that's what our heads talk to, and now turn to the merits. Sovereignty has two meanings in law, and it's important the court understands these two different meanings. The first is an external meaning. It means that when South Africa as a sovereign state, as one of the members of the family of nations, interact with all other states around the world, it has what I call, and what we submit, is external sovereignty. Some other countries can't just come into South Africa, invade or arrest or investigate crimes in South Africa. That would violate South Africa's external sovereignty. International organizations have no rights to be in South Africa other than through South Africa's consent on the international plan, and we emphasize on the international plan. And that's what we call external sovereignty. There's a different type of sovereignty which this case is concerned about, and only that, and that's internal sovereignty. And we make the point in paragraph 9, and perhaps I should just read what we say internal sovereignty means, which is what this court is concerned with. What it concerns the power of a state to make laws for its territories and to regulate its own processes. And we refer to 1924 Appellate Division Authority. Each state throughout the world is free to determine its own internal sovereignty arrangements. Thus, there are certain states in which Parliament, other states where the monarch, and others where the Constitution is supreme. And what is South Africa's internal sovereignty about? The Constitution. It's not Parliament that is supreme in South Africa. It's not the judiciary, it's not the executive, it's not the monarch, it's the Constitution. And that's what this case is about. What does the Constitution say about the conduct of the 17th of October 2016 of the executive? And that's what this is where this case is centered. And we come to that as we develop our heads, and we say that the Constitution is supreme, and for that purpose, in 1994, when the interim Constitution was adopted, and the court will look and see that Section 231 of the interim Constitution, that's Act 200 of 1993, is not dissimilar in effect to the current Section 231. When it was enacted and the Constitution broke from the past, what was it breaking from? Leave aside the fact that it was breaking from the racially offensive issues. It was also breaking from a system of government, the way the government ran things. And one of the points that we make is that in paragraph 16, prior to 1994, the executive had the power to enter into international agreements without reference to Parliament. And that's also an appellate division case of 1965 in footnote 18, where the appellate division said it's common cause in trite law, I think, that in this country, this is 1965, the conclusion of a treaty by the government with any other government is an executive and not a legislative act. And the real question is, what did 231 of the Constitution do to that common law? That was under the prerogative. So prior to 1994, it was the prerogative of the king or the state president to have a relationship with other states on behalf of South Africa. That's changed for purposes of this internal sovereignty issue. Of course, externally, it will always be the executive who interacts. But for purpose of binding South Africa, this is important, this distinction, for purpose of binding South Africa, it's Parliament that has this role. Mr. Bunden's made that clear this morning. And the word binding, one sees clearly in 231.2, and it's only the National Assembly and the National Council of Provinces that may approve by resolution an international agreement, and then it becomes binding. And we make the point, Leonard has made it, But we make the point that although the constitutional or the laws don't provide for who may withdraw, it's common sense that it can only be Parliament when one considers that it is Parliament that has the power to bind and Parliament to have the power to withdraw. And that's set out in paragraph 47 of our heads of argument, where we deal with that. We do just want to touch upon an issue before I leave this topic. What is said in paragraph 47 is, we say, it is an established and common sense proposition that where a constitutional statutory provision confers a power to do something, that provision, so in other words, there's a statute that gives the power to build a dam. The statute would also give the power to a particular administrator or whoever the person is to necessarily confer the power to undo it as well. It's common sense. And we submit that Justice 231 gives the power, and we want to emphasize this, the power to Parliament, the National Assembly and the National Council of Provinces. It similarly is those two bodies who have the power to withdraw from the Rome Statute or any multilateral treaty that South Africa is a party to before it becomes effective in South Africa. And we want to emphasize that in South Africa, because this case is about the internal sovereignty issues, the internal domestic arrangements that South Africa has vis-à-vis its law. I want to turn, if I may, to what the government says is the case. I've already made the point that the government may try to make the point that it is the government, and I use the government meaning the executive, understand the distinction. But on paragraph 112 of the government respondents, the executive respondents, its argument, they deal with our argument, CASAC's argument. They say in the first instance that we contradict the factual basis advanced before the Constitution in support of direct access. Now, it's true that CASAC approached the Constitutional Court on the basis that the Minister of International Relations and Cooperation signed the notice of withdrawal on behalf of the President rather than on behalf of the Executive. And it was done on the basis that the President was head of Executive, and then the Executive now argued, the Executive said, the CASAC now argued that she did this on behalf of the Executive. That's true. We do say that. And then when the Constitutional Court rejected the exclusive jurisdiction approach, CASAC took the view that the DA was correct in its formulation of a particular issue. Then they say in paragraph 113, and I just want to trawl through these four paragraphs, 113 to 116, to demonstrate how we would submit that the government respondents, the executive, have misconstrued our argument, but not only our argument, they've misconstrued this notion of the debate between internal and external sovereignty. And that becomes clear from their heads of argument in these paragraphs. They say, in paragraph 113, CASAC's formulation of the legal issue is also wrong. The question is not whether the two presiding officers have the power to withdraw. The question is whether parliamentary approval is required. It is nonetheless significant that CASAC at least concedes that prior parliamentary approval is not required. And they underline the word prior and they use the word not. But that misses the debate completely. It's not about prior approval. It's that they, the executive, have no power to act at all until Parliament have passed a resolution under 231(2). So what we want to do is to make sure that the court doesn't buy into this wrong formulation suggestion by the executive. Our position, and it's stated there in the second last sentence of paragraph 103 as quoted by the executive respondent, says, its position is, that's Cassidy, the sequencing argument is irrelevant. The only issue is where is the power to bind located? And that's what I've been going on about as far as this debate between internal and external sovereignty. The lawfulness of conduct is to be determined at the time of the conduct. Sequencing becomes irrelevant. And it's a red herring, the whole sequencing debate between the DA and the ministers. Its case is that all this talk of sequence or post versus prior approval is obfuscation, and we stand by that submission. It's about power. Who has the power? Under South Africa's constitutional scheme, the Supreme Court tells the court who has the power, and the power is in the National Assembly and the National Council of Provinces. Then in 114 they say that it is the DA which obfuscates by introducing all the talk of sweepers. it follows that CASAC in fact repudiates the central structure of the DX case. Then they say on the government approach, and on the facts of this case, even were the power to locate in Parliament, then Parliament in any event now seized with a decision whether or not to approve the withdrawal. That's the end of the case for the government, quite frankly. It's the end of the case. The government accept, effectively, that were the power to be located in Parliament, then it is Parliament who is now seized with the decision. I've made the point. It's no good. The determination of the lawfulness of conduct is at the time. If the power was located in Parliament, the fact that Parliament is now seized with this is interesting, but utterly irrelevant from a validity point of view. So we would submit that when the government say that on their approach, that Parliament is seized with it, is uninteresting. Then in 1115, 115, CASAC also advances an argument which is entirely inconsistent with the authority it cites. And then there's reference to a case called Kaunda, which we cite. And they also cite it as it happens. What they say is, it's claimed that CASAC, at one point in South Africa's history, prior to 94, that's government's point, would have sufficed to place this issue within the realm of the executive's competence, and accordingly called for a degree of deference, but no longer. That's our argument, and they quote it. Then they say, for this proposition, CASAC cites Kaunda. And then we say, well, that we would ask the court to have regard to the following. They then say, for this proposition, CASAC cites Kaunda, correct, but Kaunda actually stressed the deference respect must be given to the executive's broad discretion. The problem is that in Kaunda, what the court said was that where the power is located within the executive, when the executive acts, it may act lawfully or unlawfully, and the court should apply deference. But the important proposition that we make is where the power is granted to the executive. And in Kaunda, it was specifically, Chaskelson CJ said, the executive's power to determine whether or not those particular arrested people in Zimbabwe would be entitled to diplomatic protection in order to avoid them being sent to Equatorial Guinea to face the death penalty. So what the Constitutional Court said, where the executive has the power, the court should exercise deference. But that cannot mean, as we would submit, that where it's not the executive that has the power, but Parliament that has the power, government responds, well, this court must exercise deference. It makes no sense, that argument, quite frankly. This case is about the power. Where is the power located? What does the Constitution say? It says Parliament has it, not the executive. So we turn to paragraph 1.
If this court is to exercise deference, is deference to who? To Parliament or to the executive?
Well, the problem for the lordships is Parliament hasn't done anything yet. That's the problem. Parliament is seized with a bill.
And I'm just trying to follow up on what you said. The argument of the government is deference to who?
Your Lordship is quite correct. Your Lordship is correct in asking. As we understand the government's argument, it's deference to them, the government. But I mean, that doesn't make sense when we're in God. They don't have the power. How do you defer to a party exercise of power?
Well, they seem to be saying Parliament is seized with the process, the court should defer to it.
No, they don't say that. They don't say that. If they said that, they might have a different argument. What they say is, the executive, in criticizing our reliance on Kaunda, that's how this issue arose. They say that in Kaunda, the court said it deferred to the executive in the first instance. That's their argument. Now we say their argument is misconceived because in Kaunda, it is true that the executive was given the power to do that which it did. So if this court comes to the conclusion, which it could, we would submit wrongly, that it's the executive who has the power to issue the notice of withdrawal, despite what 231(2) says, then there could be an argument, and I say could, no higher than that this court could perhaps defer to this exercise by the executive. But they don't even get there, and that's why we said that their whole premise of the deference argument doesn't go anywhere. It can't go anywhere because they don't have the power. The Constitution made that clear. If this was prior to 1994, I might be in some difficulty making this argument. But we're now in 2016, and we know what the Constitution says, so therefore we have that difficulty. There is no deference argument.
I think the difficulty difficult here is dealing with their argument. Your argument is the action was unlawful, declared to be so. But you are saying they are saying defer. But you say they say defer to the executive. So I read their position correctly. They say, well, court, Parliament now has this process under its hands and defer to it. But as I say, as you're trying to make their argument, maybe the argument is best left to them.
Yes, but the point I don't have a right to reply on this. So I want to make the point that in our heads of argument up front, before they filed their heads, we made the point that Parliament, being involved in the process of repealing its parliamentary rules, made the same point. And what did the Constitutional Court, the majority of the Constitutional Court, Moseneke, no, that's not the way it works. If there is unlawfulness at any particular point in time, I want to emphasize this point in time, the process thereafter is uninteresting for the purposes of the court today. And that's the point that we make. So what we say in their paragraph 114, 115 goes, and I need to deal with it now because I'm not going to have a chance to reply. 116 on page 52, calling the Cassacks case is legally and factually flawed. And then they say, its attempt to strengthen the DA and what it implies is appropriate political warfare turned into lawfare is misplaced. And I do want to turn to that, my lord, because what we say is this. Your lordships will be aware of the DA's long-standing and long-running saga with the SABC, and in particular, the Minister of Communications appointment of Motsoneng. And what we said in our heads of argument in paragraph 20 was that to the extent that the court may regard these types of cases, the context, as what Davis J. said was lawfare. In other words, in the quote in footnote 20, the use of law as a replacement for political warfare has become commonplace in South Africa. And we ask that the court turn to it. There's an important sentence in Davis J's judgment, which we've commended on the court to adopt the approach that Davis J suggested. This is in footnote 20 on page 9 of our heads. And certainly the questions from the bench to our learned friend about how this question is well, the DA can debate this in Parliament, we say that those are possibilities, but they're not relevant to lawfulness of conduct at a particular point. What Davis J said in paragraph 4 of his judgment, reported in 2016, volume 3, South Africa 468, it's Democratic Alliance with the South African Broadcasting Corporation. And this was to do with the appointment of Motsoneng by the Minister of Communications. What he said was this: it might have been expected by the designers of the Constitution who laid out an intricate set of rules dealing with Parliament that the official opposition in Parliament would have viewed the latter institution as the preferable location for disputing his appointment. That's the appointment of Motsoneng. But lawfare, the use of law as a replacement for political warfare, has become commonplace in South Africa. The applicant thus based its case on arguments which contend that the decision both to recommend and later to appoint Mr. Motsoneng as the CEO are procedurally and substantially irrational. Then important sentences, and we would commend the following sentences to the court. These arguments require this court to examine and evaluate the merits of these submissions, notwithstanding that this dispute can be described as lawfare. It is the court's role, and we would submit your lordship's role, to examine whether the appointment, and we would say the notice of withdrawal, was made in terms of the principles of legality, only after which deference must be paid to the choice of a democratically elected minister. Courts are the custodians of the principle of legality as it is sourced in the Constitution. Where this principle is invoked, courts are obliged to enter the arena. Beyond the scope, the invitation to be custodian must be firmly refused. And we would submit similarly. So, my lord, those are our submissions. I see that I've run into a time bar or a time issue. I do want to turn to the notice of motion to end. We would submit that the first port of call should be that the court should grant the application to intervene. The second is the court should make a declarator that the notice of withdrawal issued on the 17th of October 2016 was invalid because it was inconsistent with the Constitution. And thirdly, the court should order, court has a discretion as to what is just and equitable, the government to right its wrong, the executive to right its wrong. The DA made a particular proposal, and that is that they are directed to revoke the notice of withdrawal without delay and take other reasonable steps to terminate the process of withdrawal. And that would be an order under 172(1)(b) of the Constitution, a just and equitable order. We would have no difficulty with that order or any other order that the court deemed appropriate to give effect to the court's declaratory order that the government acted unlawfully, including one, and your lordships will find it, I'm not going to refer to it now, in Casak's application to the Constitutional Court. It was a slightly differently reformulated or formulated just and equitable prayer. The court can have regard to it when it considers its judgment. And fourthly, as far as cost is concerned, we would submit that because Casak is intervening as an applicant but not as an amicus, it would be entitled to its cost as it pleases the court. And we only ask for costs of 2 counsel despite the fact that they have been 4.
Thank you. Next, Mr.
Thank you, my lord. I appear to be on the vanishing end of the day towards lunchtime, basically. And your lordship resigning
Some
will
people
begin.
say it's better before lunch than after.
I'll take that guidance. If I might begin, my lord, by handing up what would be, by comparison with what's really been used, called a very modest bundle that's only 1 page. I will come to that authority in a moment. If I might begin this way to highlight the scheme of the argument. The 6th respondent, Sol, comes to this court, and of course it supports all the submissions that have already been made by the other parties. But its submissions stand as a separate and an independent basis for submission for why the notice of withdrawal is unlawful and falls so to be clear. In other words, whatever the court finds in respect of the debate so far under Section 231, it is necessary, nevertheless, for the court to grapple with the arguments that will be advanced now because they stand as an independent basis for why the decision we submit fails the test of legality. And so our submissions, in other words, are separate from what has gone before, although they do, of course, back up that which has already been submitted. In that respect, we would simply wish to highlight 4 guiding principles at the outset of the address. They go to the question of review and the reasons that are given and the legality standard. The first principle is this. The government has given its reasons for the withdrawal. In this case, the government has given its reasons for the withdrawal. Those reasons appear in its declaratory statement. According to the government in its own answering affidavit, at paragraph 30, record 176, the government says that the reasons for the decision that is impugned before this court are the reasons contained in the declaratory statement. So that's the first place to find the reasons. But there are 2 other places in which reasons are also found, and they are in volume 3, page 207, and volume 1, page 50. And I don't need to take the court there. It's enough to highlight that the same language is used in both places. These are the letters that the government wrote. Volume 1 is page 50. Volume 3 is page 207. Volume 1, page 50, is the letter written to the National Council of Provinces, dated the 21st of October. And that's the letter written by the Minister. And the same letter, in effect, is written to the Speaker, and that is dated the 20th of October, and that is at page 207 in volume 2. But in both of those letters, it's very important just to see, one takes, for instance, volume 1 at page 50, that there the Minister says that he is setting out his reasons for the decision. One sees the second paragraph after he's done the honorific as to who he's addressing, he then says, for a number of very important reasons, on 19 October, the Cabinet took the following decision. So we simply submit that the reasons for the decision are those contained in the contemporaneous statements made by the Minister to the respective speakers of the National Council of the Province, and of course the declaratory statement. So those are its reasons. And it may not, the government may not, and that's the case which I've just handed up to the Lordships, the government may not provide different reasons or rely on reasons that come after the fact. It is bound by the reasons it gave for the decision to withdraw. And it is no good for it ex post facto to retrofit its reasons. And that has been made clear in the decision that I handed to your Lordships. It's the NTM case, it's a decision by Ladyship Madam Justice Myatt, and where she very helpfully quotes from the leading authority. She starts off at paragraph 95. I won't read the whole quote, but just to highlight, she says, as stated by the English courts in this respect, a decision maker such as the CASA is generally barred from justifying or retrofitting any decision ex post facto. Then she highlights the English authorities in this regard, and your Lordships cast your eyes down to paragraph 97. Your Ladyship says the above view is also supported in the case of the SCA decision of the National Lotteries Board, and where she quotes what His Lordship Justice Pichalia said there. The duty to give reasons for an administrative decision is a central element of the constitutional duty to act fairly. It goes on. In England, the courts have said that such a decision would ordinarily be void. It cannot be validated by different reasons given afterwards, even if they show the original decision may have been justified. Why? For in truth, the later reasons are not true reasons for the decision, but rather an ex post facto rationalization of a bad decision. So the government has given its reasons, and those are its reasons. It cannot give other reasons. The second principle we respectfully highlight for the court is that those reasons, as given by the government, confirm that the government's decision fails in material respects the legality test under our law. We have in our written submissions at paragraph 13 highlighted the principles of legality. I don't need to, of course, take the court through those principles, but it is enough to just remind the court, for purposes of what comes later in my submission, that the legality test demands that the government may not commit material error of law when it takes a decision. It may not commit a material error of fact when it takes a decision. And it must take into account clearly relevant considerations under the legality test. And as the SCA said in PEPCOR, that is not an authority that we've quoted directly in IDES, but if I might just give the authority and the passage. It's in PEPCOR 2003, volume 6, SA 38, SCA, paragraph 32. The SCA said in respect of legality reviews that a power exercised in the public interest must be exercised properly, that is, on the true facts. So you may not commit any of these material mistakes, and you must take the decision on the true facts. The third principle to stress is that if any one of the reasons that has been given by the government for its decision is bad in a material way, then that casts a shadow over its decision entirely. If any one of those are materially bad decisions, that is the end of the rationality of that decision in its entirety. And that's made clear in our law by the very famous decision of Patel versus Wickbank, the Lordships will know it well, 1931, it's TPD 284 at 290. And that decision has been updated in our law by His Lordship Justice Cameron in the Supreme Court of Appeal decision of Rustenburg Platinum Mines. And for your Lordship's benefit, that's 2007, volume 1, SA 576, Supreme Court of Appeal at paragraph 8. And there, just to snapshot what Justice Cameron said, he said, a court is not obliged to pick and choose, this is at paragraph 8, the court's not obliged to pick and choose between the reasons to try to find sustenance for the decision despite the bad reasons. Once the bad reasons played an appreciable or significant role in the outcome, it is in my view impossible to say that the reasons given provide a rational connection to it. So we would submit that any one of the bad reasons which I'll come to would be sufficient. But in any event, we highlight that they are cumulatively bad. As a result, each one of them is bad, and so the illegality is compounded. And the fourth and final introductory principle is just to stress that in this case, it is necessary with the greatest respect for this court to decide all the issues. To decide all the issues that have arisen.
Yes.
And that is being made clear most recently in a decision by the Supreme Court of Appeal of the 2nd of December, just a couple of days ago. It's the Minister of Justice versus the South Africa Restructuring and Insolvency Practitioners Association. It's 2016, ZASCA 196 at paragraph 38. ZASCA 196 at paragraph 38.
Is that the judgment by my chocolate cake?
Yes, that is. And it relates to a judgment by, I learned from Mr. Katz, as an acting judge, where Mr. Katz was dealing with a whole range of decisions, a whole range of reasons rather, in the High Court for a particular decision, and found that for one of the reasons the decision was bad, but he was encouraged to decide all the other reasons as well, because he recognized that the case may well go on appeal. He did that in the circumstances, and he cited S versus Jordan, the Constitutional Court's authority in this respect. And ultimately, from that passage, paragraph 38, the court says that approach adopted by Katz AJ was the appropriate approach, particularly because this case was ultimately destined to go upwards. And with respect to this case, everybody agrees that this case is likely to end up in Braamfontein, as Mr. Butlander has said. So, well, of course, we live in the hope that, but we suspect that it may well go upwards. But to the point, to this point, Your Lordship presiding, if it does go upwards, the benefit will be, and particularly because of the short time period of a year, the benefit will be that there will be then finality, at least from this court below, going upwards on all the questions. It will assist so that the Constitutional Court, if it comes to the court, doesn't have to deal with these questions effectively as a court of first and final instance. And that's the importance of the principle. So we submit that all the particular grounds of challenge are worthy of consideration and determination by the court. With those introductory principles, if I might then turn to effectively the 4 reasons which we are going to rely on in our submissions to submit that the decision to issue the notice of withdrawal was irrational. The first is the question of the alleged conflict for South Africa between the Rome Statute on the one hand and South Africa's immunity obligations on the other hand. The government says, and it says this in its declaratory statement, as highlighted at the beginning, that declaratory statement, it says, is its reasons for the decision. At volume 3, page 273, this is what it says, midway down the page. In 2015, South Africa found itself in an unenviable position where it was faced with conflicting international law obligations which had to be interpreted and so on. Then a little further down it said, South Africa was faced with the conflicting obligation to arrest President al-Bashir under the Rome Statute. So there's the Rome Statute duty to arrest President Bashir. What is in conflict with that? The statement says the obligation to the AU to grant immunity in terms of the host agreement and the General Convention on the Privileges and Immunities of the Organization for the African Unity of 1965. So according to the government, the obligations tearing it in 2 different directions. On the one hand, the Rome Statute's obligation to arrest, on the other hand, the AU's obligations to respect immunity under the host agreement. But with respect, that cannot be as a matter of law, because the Supreme Court of Appeal in the Bashir case held emphatically that the hosting agreement did not confer any immunity on President al-Bashir. So there's no obligation in that direction for South Africa whatsoever. Our law is clear. The Supreme Court of Appeal has made that statement emphatically. And if your Lordships would turn with me very briefly to volume 1, where His Lordship Mr. Justice Wallace's decision is to be found. Volume 1, page 86, where it starts.
Is that the record?
Volume 1. Yes, the record. I see the judgment of His Lordship was sufficiently important to find its way to the record as well. At page 86 of the record. It's really paragraphs 40 and 47 that your Lordships need to have a quick regard to. That paragraph 40, you'll see His Lordship Mr. Justice Wallace under the heading Article 8 of the Hosting Agreement. This is the very agreement the government says it's conflicted by. He says, in paragraph 40, this was not only the principle but also the only argument advanced by government before the High Court. And then if you turn over the page at page 87 and paragraph 41. He says, the High Court gave the argument by the government short shrift. It said that on its terms, the hosting agreement conferred immunity on members of staff of the AU Commission and on delegates and other representatives in governmental organizations. And this did not include member states and their representatives or delegates, in other words, President of Sudan, al-Bashir. And then if your lordships turn just a little down to page 90 at paragraph 47 of the judgment, this is the conclusion. His Lordship, Mr. Justice Wallace says, the necessary conclusion is that President al-Bashir was not a person included in the reference to delegates in Article 8 of the hosting agreement. As such, the hosting agreement did not confer any immunity on President al-Bashir, and his proclamation by the Minister of International Relations and Cooperation did not serve to confer any immunity on him. So, with respect, at the time that the SCA made that statement, it was already the last word on the subject, and it made it clear that there was no obligation owed by South Africa under the host agreement to President Bashir in respect of immunity. What has happened since the judgment is that we now know the government has withdrawn its appeal against the SCA's decision. So the SCA's findings have now, in fact, become biblical and binding. And they make it very clear there is no such conflicting obligation for South Africa. It means that the purported obligation to grant President al-Bashir immunity in terms of this AU host agreement, in which the government told the UN was in conflict with the Rome Statute, and therefore justified South Africa's withdrawal from that statute, a momentous move on the international stage, had been definitively already held by South Africa's very courts not to create that obligation. And with respect, that is a fundamental error of law, which vitiates the decision after the outset. There's another conflict that the South African government said it was under. And with respect, our learned friends have not dealt with that argument at all. There's no comeback from them in the affidavits or the heads on that argument. The second argument raised in respect of the conflict of immunity and the duty to arrest is in relation to customary international law. So now we've moved away from the AU, we move to customary international law. And the government says that it had to withdraw from the International Criminal Court because the Rome Statute forces the government to arrest persons who enjoy immunity under international law. And the only way to escape from this obligational bind was to resile from the ICC. But with respect here, going back to what the SCA said in PEPCOR, when you consider the rationality of a decision-maker's decision, you have to ask yourself, was that decision based on the true facts? What are the true facts? The true facts are that this concern by the government is focused on al-Bashir. We know that the government's concern is effectively on one man, and that's already highlighted in the declaratory statement at page 273 of the record in volume 3. I don't need to take your lordship there, but the concern is al-Bashir. And it has to be that the government's concern is in truth only with him, because he's the only head of state currently wanted by the International Criminal Court. The only head of state, in other words, who puts South Africa in this potential conflicting situation between its duties under the Rome Statute and its duties to the AU to respect his immunity.
But wouldn't that concern be al-Bashir or any other head of state when they come in that position?
Yes, that is potentially so. But in relation to the facts here and the reasons that were given, the reasons were given in the declaratory statement that would, because Sudan and President Bashir had created this international conflicting obligation, South Africa had to withdraw. It may be that there are other people, it's never identified those other people. The government has filed numerous affidavits, both in this court and in the Constitutional Court. It's never said who it needs to negotiate with, have a rapprochement with, other than President Bashir. And the fact is, that makes sense with respect to law, because there is no other person that the International Criminal Court currently wants. And it is in that context that the South African government speaks in its declaratory statement about its conflicting obligations for Sudan, Bashir, and the Rome Statute. So the true facts are that it's Bashir, and only Bashir, that is wanted by the ICC and that creates this conflicting obligation for South Africa. But that's an outlier case in the extreme. If I might just highlight for your lordships why it's an outlier case in the extreme. The first is the vast majority of accused that are wanted by the International Criminal Court don't attract any immunities at all. That's because they are the soldiers, the rebels, the rapists, who don't have immunities under the Rome Statute whatsoever. They rape, they kill, they maim, and they don't get to have any of these debates around their immunities around them. The second point is, of course, that President al-Bashir is from an outlier state itself within the Rome Statute scheme, because Sudan is not a party to the international criminal court. His case, his crimes, are before the ICC for the exceptional reason that the genocide that he allegedly masterminded and was referred to that court by the Security Council. The point is, it's an outlier case involving a non-state party. What it doesn't answer is, what about the 134 states that are members of the International Criminal Court? And each of those states have, under the Rome Statute in Article 27, recognized that for their heads of state, there is no immunity that attaches. That International Criminal Court can prosecute heads of state, be they from Germany, from Canada, from Kenya, from Spain, from South Africa, because they've already decided in advance by becoming a member of the statute to waive immunity. So with those facts in plain sight, I might then return to the question of rationality of this decision. Those facts in plain sight give rise with respect to three perversities. The first perversity is that on South Africa's perceived concern for Bashir's immunity, we have withdrawn our support for a court that is currently seeking justice for African victims in the Central African Republic, in Uganda, in Mali, in the DRC, in Cote d'Ivoire, and the thousands upon thousands of victims of crimes in those African countries are now no longer with the support of South Africa, seeking the justice that only the International Criminal Court can provide. And those victims are all African, and their assailants are all, with the exception of al-Bashir, are all soldiers and rebels who don't have immunity. The second perversity is that we've withdrawn from a court whose founding instrument in Article 27 confirms that 134 states have accepted the right of the International Criminal Court to prosecute their heads of state. And currently the International Criminal Court is not, despite what the government repeatedly says, focused only on Africa. The court is in a preliminary examination in Afghanistan, in Colombia, in Palestine, in Ukraine. It's considering the crimes committed by the British military intervention in Iraq. And it's looking at the result of the crimes committed by Israeli commandos and their attacks on a humanitarian flotilla destined for Palestine. And recently the court has opened an investigation in Georgia, which has not pleased Russia, as one can imagine. And so we come back to Bashir, and here's the final perversity and irrationality writ large. The government says that it has to respect the immunity of Bashir, yet the Rome Statute forces South Africa to arrest Bashir. That's their argument. And so the only way out of this bind for them, they say, is to respect his immunity by leaving the Rome Statute. But that's a fundamental mistake by the government with respect, because the government can't avoid arresting him. And it can't respect his immunity in this way because of Article 127, sub 2 of the Rome Statute. Your Lordships would have seen Article 127.2 referenced in the heads of argument. I'll come back to it in a moment, but if I might just snapshot it. And the government doesn't deny that this is the effect of Article 127, sub 2 of the Rome Statute. You'll know Article 127.1, on letter from Mr. Butler has already dealt with it, allows for the withdrawal of a state from the ICC scheme. But Article 127 sub 2 is a vitally important saving provision. It says that for any cases or situations that have already begun, in respect of President Sudan, that's clearly, President Bashir, that's clearly true, for any cases that have already begun, and any obligations that have already arisen for a state in relation to those obligations, those have arisen for South Africa, to no question, those obligations to arrest and to cooperate with the International Criminal Court continue despite that country residing in the Rome Statute.
How do we make the argument of the government much more symbolic than it actually is? As I read, they seem to be saying, and I must say they won't argue their own case. Al-Bashir's case may have been a kickoff. It has led to decisions by the courts. It has brought them to a realization that the program they would like to follow in Africa, peacekeeping, diplomatic interventions, and so on, may be compromised by its obligations under the Rome Statute. In other words, they're not saying the whole reason is we don't want to arrest al-Bashir. It looks like our peacekeeping mission in Africa, they come in conflict with our obligations under the legislation.
Yes, but with respect, this is the difficulty for the argument.
Well, but if that is their argument, then let that be their argument. Let that argument not be reduced to they think that escaping the obligation to arrest others.
With respect, my Lord, their reasons for withdrawing are what are being focused on.
Yes.
Their reasons are the reasons that they gave at the time. And in those reasons, they say their conflict arises from President al-Bashir.
But don't they refer also to their peacekeeping mission in Africa?
Yes, they do broadly.
Yeah.
But in respect of their conflict, as they say, they have an obligational conflict. They, in direct terms, don't reference anybody but President Bashir. But all we would highlight is to the extent that President Bashir was the proximate cause for them withdrawing from the statute. It has to have been that President Bashir was the proximate cause. Leave aside whatever else they may in due course come to say about who else they want to negotiate. President Bashir, there can be no debate, was the proximate cause, and they themselves reference him as the reason for having the conflicting obligation. If that's so, the difficulty for them is that to withdraw from their own statute in order to show respect for President Bashir's immunity, so that this type of rapprochement can happen in relation to him, that is entirely irrational. Because Article 127.2 of the Rome Statute specifically says that you can't, in fact, have that rapprochement with him because the obligations for South Africa to arrest and to cooperate with the ICC continue. That's not to small draw their argument with respect. That is to highlight that that was their argument, their reason, that was the proximate cause. And if that is what they say was their proximate cause, it fails the test because immediately there is an error of law committed by them. Article 127.2 will immediately mean that they can never arrest President Bashir, ever, until such time as he's been arrested by the International Criminal Court and either been acquitted or has been
They might be saying, all right, we have the obligation to arrest Bashir. Do we want to wait until we have an obligation to arrest other African heads of states and we are making a choice, to use their language, we are privatizing Africa?
That is a separate debate, a separate reason that they've raised.
Yes.
On this reason, we're sticking to that for present purposes. And that's the point. Whatever their separate reason may be about peace and justice and the need to do so, there are other arguments we've highlighted why that doesn't work. But as regards this reason that they've raised, they are hung by their own tires because unfortunately for them, 127.2 does not permit for President Bashir to have any opportunity to come to South Africa. He would have to be arrested, is the simple point. That's the first ground. So they've not considered the African Union immunity obligations properly, and they've not considered the customary international law obligations properly. They've created for themselves a tension which, frankly, is a false tension. The second point arises in respect to the African court. Your Lordships will see at volume 3, page 207, that the Minister's statement to the Speaker is set out, recalling that at the beginning of that statement he describes that that this statement contains a number of his important reasons. And if your Lordships turn to page 209, the bottom of that page, the following is said, the last paragraph: South Africa remains fully committed to the fight against impunity and to hold those who have committed crimes against humanity and other serious crimes accountable for those crimes. Then a little further down, it says, for this reason, South Africa will work closely with the African Union and with other countries in Africa to strengthen the continental bodies, such as the African Court on Human and People's Rights, created to deal with such crimes, and to prosecute the perpetrators, importantly, irrespective of their standing. So South Africa says, we will withdraw from the International Criminal Court, but that's no regression. There's no cause for regret, they say, since the accountability that the ICC would have achieved will now be achievable through different means, the African Court. Well, with respect, there are a number of errors of law, or to put it in the PEP language, a number of failures to appreciate the true facts. When one regards the statement by the Minister, those were his reasons. The first difficulty is that the African Court on Human and People's Rights was not created to deal with such crimes, and it has no criminal jurisdiction. You know that. The papers have made it clear. If it's ever to be accorded that jurisdiction, it will be through a convoluted amendment to an existing amendment to a protocol for merging the African Court on human and people's rights to become the African Court on Justice and Remedies. But with respect, one again needs to look at the true facts here. That protocol conferring criminal jurisdiction on the African Court, it's known as the Malabo Protocol, it needs 15 ratifications for it to become effective. It was adopted in June of 2014, more than 2 years ago, and there's not one ratification. So there is no African Court with an international criminal chamber that can plausibly stand as an alternative. There's no substitute, in other words, despite what the minister's statement suggests, that there will be a substitute removed from the ICC, but don't worry, there will be an African Court. There is no substitute in law. Simple and straightforward. And South Africa has not even signed the Malabo Protocol. So it's not possible with respect in the same breath to say South Africa is fully committed to the fight against impunity, and then in the next breath to say that that commitment is affirmed by and will be effected through the African Court. It's simply not so. If the end, if I might put it in the language that as lawyers we understand, is the rationality language, if the end is accountability, you cannot achieve that end through the means of the African Court. There's simply no relationship between means and end. There is no such African chamber. So if you're on a car trip to Cape Town, you get in the car and you say, I'm going to Cape Town with your passengers in it, and halfway you decide, oh, I don't like this car anymore. I'm going to get out, I'm going to get into another vehicle that's standing on the side of the road. It looks like a vehicle, but it turns out it doesn't have an engine and it's got no petrol. And you say, well, you're only fooling yourself if you say, well, I'm still on the way to Cape Town. And with respect, you're also doing a huge disservice to your passengers, particularly if you recall, these are not ordinary passengers. These are the victims of crimes, the world's worst crimes in the African continent. So it is with respect to manifest irrationality for the minister to have said what he said. The government in its heads of arguments in paragraph 120 complains that SALC attributes incorrectly the statement to the minister regarding the status of the African Court. With respect, it's difficult to know how we attributed it to the minister incorrectly, because the minister's reasons, given contemporaneously in support of its withdrawal, and which was said to be the reasons, say exactly what we read to your lordship, and not just once, but twice, to the National Council of Provinces and to the Speaker. The minister is emphatically saying, even though he may have erroneously believed it, or not understood the true facts, or been given the true facts, he's emphatically saying that there is such a court, and that it will be the alternative means by which South Africa, truly committed to justice, will achieve justice. So now the government says, in an ex post facto reason, in its heads of paragraph 120, it says the correct position is that the minister expressly referred to the operationalization of the criminal chamber of the African Court. And they, in this respect, refer to the statement, note the bar of the 3rd of November, and that's at volume 9 of the record, page 888. It's a statement to the National Assembly. They reference that. But with respect, that's 6 weeks after the withdrawal notice that had been given. It's after SALC had raised this very point, notably in its affidavits in the Constitutional Court. And it's precisely why what I read to your lordships from the MTN case at the outset of the address is pertinent. Our courts have held it is impermissible for the government to justify or retrofit any decision in an ex post facto fashion.
But the passage that you quoted, actually, I seem to recall that he went on to doubt whether that English law has been imported into our law.
He said in the next breath, he said, it's not necessary for me to decide this question.
He left the point open.
He left the point open. Then he went on, though, further in his judgment, to say, but the reasons are not going to work here because they came after the fact. And in any event, and that's precisely why, with respect, Justice Makaka, we have referenced the decision of MTN Networks, which is a later decision, of course. It references that by the ladyship, Justice Mike. So we would submit, at least on that authority, certainly now is the position.
How much longer are we still going to do this?
Well,
I know that you have ratioed time amongst yourself, and she would serve as the president.
I have 2 more points to raise by way of review grounds, and it shouldn't take me more than 15 minutes. I'm in your lordship's hands.
No, the time is far apart. It's not just our convenience, we have court stuff here. We have other obligations. It will just us sitting with you. We will sit down again all that.
We are
I think if you have 15 minutes more to traverse, you might as well do some time. Thank you. The Court of Justice.
All rise. Ahora me tengo que ir a for the next 15 minutes. Yeah.